Have your attention, we will call the January Board of Zoning Appeals, the meeting to order. We have a prepared agenda that has been advertised. If anyone wishes to withdraw, they may do so at this time. And if hearing nobody want to do that, we will proceed with the agenda as presented. We have a court recorder here this morning to take a record of our proceedings. The court recorder is provided by Wilson County. If you as an applicant or an individual wants a record of a particular case, that would be at your expense, and you need to see the court recorder after our meeting is over. If you plan to make a statement in front of the board, you need to be sworn in. This time, would you please raise your right hand? Do you solemnly swear that the testimony you're about to give to the board to be the truth, the whole truth, and nothing but the truth, so help you God? I do. Just as a reminder, if you would, to please silence your cell phone or put it on vibrate so we won't be disturbed with that. If you would, when your case is called, we'll have the applicant come to the podium first. Always give your name and address for the record, and then after the applicant has said his, then we'll let anybody from the public that has any public comments, we'll let them speak as well. The planning staff has made recommendations to the board regarding each case, and we will be reading those recommendations and using those when we render our decisions. To the members of the board, you have the minutes from the December meeting. Are there any corrections to the minutes from December? If there are no corrections, do we hear a motion for the to approve the minutes?
Motion to approve.
Motion. I have a second.
I'll second.
Everyone in favor vote aye. Aye. And the motion carries. All right, getting into the prepared agenda here. The first case will be case 4222. Edward Haggerty is requesting a renewal for a short-term rental. The board approved the short-term rental on February 16, 2023 for a period of 1 year. Property is located at 105 Riverside Drive, Lot 25, Parcel 4, Wilson County Tax Map 28. The property consists of 0.68 acres and is zoned A1 agricultural. We'll get staff recommendations on 4222.
Yes, Mr. Chair. Regarding 4222, it was presented in November. The applicant had originally requested a deferral till February. This got added to our agenda by mistake, so no action will need to be taken to you.
Okay.
And it'll be on your February agenda as originally requested. It was put on here on our error.
Okay. All right. No actions needed on that one.
No, sir.
Okay, then moving next on the agenda will be case 4233. This case was deferred from the December 19th meeting. HR LLC is requesting to use the property for a short-term rental. The property is located at 6505 Hickory Ridge Road, Lot 1A, William Sherrill Estate, Parcel 69.02, Wilson County Tax Map 70. Property consists of 25.48 acres and is zoned R1 residential. Staff recommendations.
Yes, sir. The applicant is requesting to use the property as a short-term rental. Staff members had received a business plan stating how the applicant considered using the property. If the use is granted, staff recommends that the business plan be made part of the approval and put the applicant on notice. If they are to add any sort of structure or expansion to the use of the property, they will have to come back before the board for a plot plan submittal and revised business plan approval. The home on file is listed as a 3-bedroom, 2-bath with limit of 8 guests. Typically, the board will allow 2 guests per bedroom, limiting the number of guests allowed to 6. Airbnb short-term rentals are used permissible on appeal in the R1 zone district with a minimum acreage requirement of 2 acres. If the board approves this request, the applicant will have to make their contact information available to WEMA, the building inspector, and the county sheriff's office. Speaking with the applicant on site, the applicant wants to have a caretaker who has experience with horses due to the facilities offered on site. This caretaker lives within 12 miles from the site. site. Since last month's deferral, the applicant has added a second caretaker for the property who does reside within 10 miles of this short-term rental property. Given the language in the zoning ordinance, staff can recommend approval of the short-term rental use for the home as the property does meet the 2-acre minimum requirement and caretaker requirements.
All right, thank you. Who's here representing this case here? Yes, sir. I don't have a name on this case, I don't believe. Give us your name and address, please.
Greg Smith. I own the property at 6505 Hickory Ridge Road.
Did you understand, you're requesting, I think, for 8 guests, but you've only, your site's only perked for 3 bedrooms, and we have a pretty strong history of only allowing two guests per bedroom.
Yes, I understand that.
Are you willing to modify the business plan to 6 guests instead of 8?
Yes, sir.
Okay. Any other questions from the board?
What's the acreage here?
25. It's actually he's kind of got I guess you'd call it a farm with a horse barn and a riding facility and.
He said
Yeah, it's
something
under the 2
equestrian.
acres.
You have equestrian farm.
Basically, yes. I mean, it has a barn that has stables, so if somebody wanted to come and stay temporarily that had horses or whatever, we could accommodate them. But at the last meeting, I had discussed the reason that my caretaker was a little bit more than 10 miles away was that she's a equestrian person. And so now I've got the other guy who's like 2/10 of a mile away, so I'm going to have I'll have 2 caretakers now, so.
Any other questions from the board? I, part of my concern was with the horses being maybe a part of this, with somebody, if a horse got loose or something happened, that you had somebody there that was pretty close by that could kind of come in there, so I appreciate that.
Sure.
All right, is there anyone here in the audience that wishes to speak to this case? All right, hearing none, I'll close the public comment period and turn into the board. Do I hear a motion or any discussion?
I'll make a motion we approve based on recommendation from the Planning Commission.
Okay. Have a motion to approve. I'll second that motion, and I'll also amend that to add that the business plan only includes 6 guests, and that the business plan be made a part of the motion. Do you accept that amendment?
Yes.
Okay. All right, we have a motion and a second. Everyone in favor, vote aye. Aye. Opposed, no. Motion carries.
Thank you.
Thank you.
Mr. Neal,
Yes.
you may need to approve that for a,
Period of time.
Period of
Okay,
time.
good point. Yes, sir. All right, we will,
Don't leave yet.
yeah. Thanks for catching that. We will open the floor back up, and do we need to do that in a whole new motion, or just?
Yeah, you need to, yeah.
All right, well, I will, we have a history of approving these in the beginning for 12 months at a time, so I will make a motion that we approve this case for 12 months. Do I have a second?
I'll second.
All right. Have a motion and a second to approve 4233 for 12 months. Everyone in favor, vote aye. Aye. Opposed, no. Motion carries. All right, thank you. All right, next case would be all right, case 4235, is that correct? Yes. Deferred from the December 19, 2024 meeting. Miller Transport LLC is requesting to use the property for parking tractor-trailer trucks for transportation of general freight in conjunction with tractor-trailer truck repair. The property is located at 5425 East Division Street, Lot 2A. Barlow and Turner is parcel 41.01 on Wilson County Tax Map 78, consisting of 3.62 acres and is zoned R1 residential. Get staff recommendations on 4235.
Mr. Chair, on 4235, the applicant is requesting to use the property for transportation of general freight in conjunction with tractor-trailer truck repair. This is not a use on appeal in the Wilson County zoning ordinance for R1 zone properties. This use would fit more within an I-1 light industrial, I-2 industrial district in the county. Given the language in the zoning ordinance, staff recommends denial. This case is currently trying to remedy a zoning violation on the property that they have on suit with the county. They did request annexation into Lebanon city limits, and that request was denied.
Okay, thank you. Who's here representing case 4235? Good morning.
Good morning. Byron Gill with Rochelle McCullough. I'm here for the applicant. I want to give the board a little bit of color to this. So my client is a small business. He's in trucking. I think there's a mischaracterization of the application. He's not doing any repairs on site. What brought us here is the client misunderstood the commercial nature of the lot that he purchased. Across the road is all industrial, and it's very much in keeping with what's across the road. There's trucking, and there's warehousing, there's everything across the road. My client's mistake, obviously.
Not to interrupt you, but what is the zoning across the road?
It's industrial.
Okay,
It is
go ahead.
So when he realized that he couldn't do it, that was by citation of the county, obviously. He goes to the city to try to, because it's in their urban growth area, so he's got to go to the city first. City says, we're not going to annex, not really going to touch it. So therefore, we're back before this board. He has a house on the property that some of his drivers occupy. So it's a situation where these trucks are not for handling freight. They're just there for the nights when these individuals who live in the home are staying there. So it's an in and out truck type situation. It's not more than a couple of trucks at a time is what he's proposing through this application, and he's not going to be doing any repairs on site. So I want to clarify all that for the board. So this ask is basically that we have a variance to have the occupants of that home, when they're there with their trucks, those trucks be there. When they're not, is what the application is. So be happy to answer any further questions about that. And
Approximately how many occupants in the home, roughly?
three occupants in the home. That's where they live when they're not on the road. So obviously they're on the road quite a bit. So it would just be when they're there to be able to park their trucks while they're there.
Mr. Chair, and I'm not going against anything you said, Mr. Gill. The packet that was submitted has that, it doesn't state the occupants in the home, so that's new information to me, which that doesn't change anything in my recommendation. It says that there could be 10 employees on site, and then it also says there's going to be a shop on the property for repair of vehicles. So, I mean, that was asked for in the packet. That's not,
Understand,
yep.
which wasn't anything I was involved with. I
Okay.
came later, but that is what we're presenting today is what I've just voiced to the board.
Right, and that is quite a bit different than what our paperwork shows. I don't know, does it need to,
I mean, they can, I guess, withdraw some of the requests. If you're going to approve a use on appeal, you can put stipulations on that to limit the truck repair out of it, and just allow more of a, it'd be more of a contractor
Well, I mean,
storage yard at that point.
I understand you may not have been a part of it. The first page, the first sheet, the first line is business to employee, 10 employees running 15 trucks for transportation of general freight. And now we're down to 3 people with 3 trucks. That's a pretty big change.
Well, and that's, like staff says, this board has the ability to put whatever conditions they want to on it. And after conversations with county commissioner in the area, the city, and my client, what I presented today is what we're asking for. And if we need to amend or do whatever, we'll withdraw the application for truck repair. We'll withdraw anything to do with those numbers that were cited in that application. And what I presented today is what we're asking for.
These pictures, I guess this is part of the packet that's dated December of this past year. It looks like there's a lot of activity, trucks and trailers, large quantities on this property.
Correct. That was what the citation came from, was they were parking multiple trucks on there. They have since rented space at a different location to do that. So, but they do have these people that are occupying the property that they really need to have the ability to come in and out of the property. That's what it's down to. So those trucks are moved to a different location, is my understanding. I haven't been out there personally in the last couple weeks, but
what does the county do to a guy that lives and drives a truck over the road? Is he allowed to park his truck and trailer at his house?
Are you talking
One
just-
person that lives in a residence.
Absolutely, yeah. You can, if that's your work vehicle, the county allows the right for any resident to drive their tractor trailer, or if they're a dump truck driver, the one.
Residential play and park it in their yard or at their house.
Yeah, and that would be limited to one, maybe two, if it's a husband and a wife doing the same profession.
Okay. All right. Any more questions from the board? Yes, go ahead.
Yeah, in this same packet, we got a whole bunch of pictures. We've got some dating back to August 7 of '24.
Well, that would be when the violation was first started with the county, and the reason there's so much time frame in there, they pursued the process to get annexed into the city of Lebanon, which in that case, they would have been rezoned, and it would have been a city issue at that point to be addressed by them. That process is 3 months in itself, and they ended up getting denied for annexation at that point, so now their next course of action is to come before you all and request a use variance.
Has it been a site visit to see what it looks like today?
I think our most recent one was in our December field reviews. The pictures that you have in the
They
packet.
went by the site today. The most they're going to see is 3 trucks.
I can't answer that.
I have the client here if you'd like to ask questions. He's signed in if y'all want to speak.
I understand tried to get annexed into the city to get it rezoned. Is rezoning it within the county not a possibility?
It is a possibility, but I've spoken to the county commissioner for the area, and he's not interested in
Okay.
rezoning to that. So that's not a possibility.
All right.
Can we not take this and have him redo this so all this is removed?
I think that's a very good option. I think we can, get into it a little further.
Are you talking about having him amend his packet and coming back before you with the amendments?
So I'd like to see this
Right, yeah.
reviewed and brought back.
Right.
All this
What
has
we
been
have
removed.
before us and what you presented are kind of a
Exactly.
long ways apart, but anyway. All right, we've been through quite a bit of this. There may be some people here in the public that wish to speak. Let me give them an opportunity. Is anyone here in the public that wants to speak regarding this case?
We haven't heard from any
Okay.
surrounding owners, so they've got no objections as far as we know, but that was my client that stood up.
All right. Okay, well, back to the board. Any more questions or discussion for the applicants? Or
I'm still not comfortable with the zoning. I think that needs to be cleared up and everything done to see if they can make it happen before we have to decide on this, because I'm just not comfortable with it.
If there's not any more questions for the public, I'm going to close the public comment period, and we'll discuss it amongst the board here. I feel like that the use before us, or what the request is quite excessive. I personally am of the opinion that it probably ought to be scrapped and just start over from scratch, to put it bluntly. I will, any more comments? I will make a motion that we deny this case, 4235.
If you're going to deny it, they've got to wait 6 months to come back before you, and if it's a denial, we're going to proceed with the zoning violation process, which would be turning over for court action. If you're wanting to see something new come before you, which Ms. Robinson insinuated, that would just be a deferral, but it's up to you to make that decision.
Let me make a motion, and then we can discuss it. How's that?
That'll work.
Is that okay?
Yes, sir.
I'm going to make a motion we deny it based on staff recommendations and the fact that it does not fit the use for R1 zoning.
Okay. Yes, sir.
Do I have a second for that, and then we can have discussion? All right, we have a motion for denial, and we have a second. Now we can discuss that. As far as bringing it back before, or an amendment, if they come into compliance, and Christopher, I guess this may be more for you, if they come into compliance, do they have to come before the board?
No, sir, they would not have to come before the board. With the current zoning, the only use that is allowed on an R1 district would be a home occupation or single-family residence. So in order to come in compliance with this use, it would require a rezoning process.
But the applicant said verbally here today, all they want to do is let 3 people that live in a house park 3 tractor-trailer trucks there.
Okay?
And according to the zoning, if you live in a house, you can drive your work truck home.
So that would be up to us to interpret if this falls within the home occupation. And I'm not in the business to figure out who's physically living in the home. That would be one route to be able to come into compliance. That's, this issue is a little bit bigger than that, so that's going to be
Right, well,
very hard to enforce.
I'm trying to shrink it and make it smaller by, we're not going to have truck repairs, we're not going to have a business. All we're allowing is what everybody has the right to do, which is
Drive
bring
their-
their work vehicle home.
Yes, sir.
Now, as far as, I don't know what the zoning are as far as how many people can actually live in a house, or if they have to be, I don't know how you deal with that aspect of it.
Well, I'm not in the business of defining what a family is either.
Exactly.
As far as that, I mean, the home occupation allows you to have one off-site employee as well. We're typically not going to allow that off-site employee to park their work vehicle overnight on the property. It would have to go home with them in that case, and then if they're reporting for business the next day to get their marching orders to go on, that fits within what we've defined as the home occupation. If that's how you want to interpret that, we can go through, but there will be follow-up visits on this site to make sure that they're not exceeding that amount of trucks.
And maybe I'm a little lost. Do you have to have a home occupation, if I'm an over-the-road truck driver, to drive my truck and park it at home when I'm not on the road? Do I have to, is that a home occupation?
No, that would not be a home occupation. A home occupation would be where you have a business running out of your home.
I'm not going with this being a business. I'm going as the people that live there have the right to
Right.
park their I
And
don't, I'm
the only-
putting too much back on you. I don't know.
The only consideration I would have with that is, and I don't have a way to verify this at present, the people living there, I don't know if they are the property owners or if they're renting the home and just living there and working. Like it doesn't allow you to buy a home and then rent it to your workers and have that qualify as a home occupation. That would be a business at that point because they're not the property owners. The people living in the home, I mean.
Right. Got any advice back here?
Well, if you're going to deny it, then it'd be up to the applicant to check with the Wilson County authorities to see whether or not they're in compliance. or
What they
not.
can and cannot do?
They can make another request. As Christopher said, you got to wait 6 months. Is a denial without prejudice in order here?
That was not my request, and that was not the motion, but they can do that. Yes, sir.
Could they do that?
Yeah, and that would allow them to come back beforehand. That would also allow them to come back without repaying the fee.
And that would allow them to come back
Without waiting 6 months?
without waiting the 6 months.
But with a new application?
But with a new application or amending this
amended,
application?
Yeah.
Saying what they're going to do
Okay,
and being able to prove it.
okay.
So if we amend the motion and do it without prejudice, they can amend their request and be back on the agenda.
They can, and that saves them the 6 month waiting
Okay.
period and also the refiling fee.
Okay.
So, you've been more than fair with it.
Okay. All right. Well, I will, do I need to make a whole nother motion, or can we just amend it?
You would need to withdraw your first motion and then.
All right, I will withdraw the first motion. So the floor is open for a motion. I will try to clean this up a little bit. I'll make a motion that we deny this case 4235 without prejudice, based on staff recommendations, based on the fact that the use does not fit the R1 zoning. Is that sufficient?
Yes.
I have a motion.
A second.
I have a second. All right. Everyone in favor of this motion, vote aye. Aye. Opposed, no. And motion is denied. Motion carries. All right. Maybe we got that cleaned up. I don't know. All right. Moving on to our next case will be 4238. Shelby Flynn, on behalf of Oakwood Hideaway LLC, is requesting a renewal for a short-term rental. The board approved the short-term rental on April 20, 2023 for a period of 1 year. The property is 400 Gilly Road, consisting of 18.97 acres and is zoned A1 agricultural. Staff recommendations on 4238.
Mr. Chair, the applicant is requesting to renew an approval for a short-term rental. This short-term rental was granted for 1 year on April 20th, 2023 with the following conditions. The maximum number of occupants is 6. The business plan is part of the approval. Any changes will be required coming back before the board. Contact information must be submitted to the building inspector's office. The business plan staff has received upholds the conditions listed above. The use and amenities of the property have not changed, nor have there been any public complaints about the property to staff's knowledge. Staff staff has received this morning information about the caretaker, and the caretaker is within the 10-mile requirement for that. So that would change the recommendation of this, that staff can recommend approval of this Airbnb request. There's no language in the zoning ordinance granting staff permission to renew short-term rental approvals. However, the board may consider this request. Staff will point out that the renewal case such as this, if the request is approved, the board typically grants an extended renewal period. That being said, this renewal has been expired for 9 months.
Okay, thank you. All right, who's here to represent 4238? Yes, ma'am. Name and address, please.
Shelby Flynn, 809 West Sagewood Drive in Gallatin.
Anything you would like to add or any comments?
I don't think so.
And you did get with staff and you have taken care of the caretaker issue?
Yes.
Any questions from the board? I guess,
How many acres is this?
go ahead.
How many acres is this?
Right over 18.
I'm sorry?
18.
18 acres? Okay, I didn't read it, I'm sorry.
They got plenty of acreage. Staff, as far as I know, you made a comment that it went 9 months, I guess, over, whatever.
Yes, sir.
There's not any, I mean, as a board, we don't do anything about that, do we? I mean,
No, that's just a point of information, because the only reason I even stated that is because last month there was one that was expired for an extended period of time. I think it was over a year in this case, but as opposed to issuing an extended approval, as in you typically do, you typically went 1 year and then the second approval is 2 years. In that case, since it was expired for so long, you just granted another year.
okay.
You need to keep up with your date of renewal.
We had a new owner who bought it in December, and I think all of the information was going to the old owner, and they did not get in contact with the new owner about the renewal and when it needed to be, is what I was told.
I wonder how much of an issue that is when they change ownership. How does the new owner know? They just have to do their own due diligence?
I
would think so, if they're, I mean, I would think yes, because if they're running a short-term rental, I would hope that that information would be given to the new current owner, so they would have that information and know that they would have to keep up with coming back before the board.
And I don't know anything about how to run these or anything. I know a lot of them are run through like national companies. Do the national companies you run through, do they tell y'all to get with county zoning, or do they even care about any of that, or can you answer that, or Christopher?
No, I couldn't answer that, sir.
They don't
I've
have
not kept
any-
up with how Airbnb policies work.
Right, and county zoning is not a part of that anywhere.
I mean, we're allowed to have county zoning to allow them.
I know, but they don't ask to have that.
No, I don't. I think you're kind of referring to similar like what the ATF require for
Exactly what I'm referring to.
No, I don't believe they're reaching out asking for a zoning letter of approval such as like what the ATF requires.
Okay.
Yep.
Yes.
Question, Chris. Chris, since this lapsed, are we taking a position that we're treating this as a new rental?
That is, well, it has previous approval. I mean, that could be one lapsed on purpose, like maybe the applicant chose to not exercise that, and then in this instance, the property's sold and the new property owner wants to renew the case. And that would be a new owner. And that's kind of what this is, because it's a new owner. It's not, the original approval was under the previous owner. So if you're asking my opinion, yes, I would probably look at it as a new case, because it's a completely new owner in this instance.
And I got a second question. Since she's in compliance now, is the staff recommending approval?
Yes, sir.
You are, okay.
Yes, sir.
All right, anybody in the public have any comments on case 4238? All right, hearing none, we'll close the public comment period. Do I have any more discussion or a motion on case 4238?
Mr. Chair, I'll make a motion to approve for 1 year based on it being a new owner.
All right, have a motion to approve for a time period of 1 year. Do I have a second?
Second.
Have a motion and a second. Everyone in favor, vote aye. Aye. No. And ayes have it. Okay, you got it approved for 12 months.
Thank you.
Thank you. Okay, next on the agenda would be case 4239. Robert Elliott is requesting a variance of 20 feet from the front yard setback requirement of 30 feet. The variance will allow the proposed detached garage to be 10 feet from the property line. The property is located at 1611 Hark Reader Road, consisting of 7.51 acres and is zoned R1 residential. Staff recommendations on 4239.
Mr. Chair, the applicant is requesting a variance of 20 feet from the front yard setback requirement of 30 feet. Staff will note that this is a flag lot, and the proposed garage will sit approximately 1,190 feet from Hark Reader Road in this instance if the variance is granted. This is not an older tract of record, with the lot being created in August of 2022. Therefore, given the language in the zoning ordinance, staff cannot recommend approval. And if you're looking at this lot, if you go all the way to the south where it opens up, the flag opens up going eastbound, that is where the proposed structure is going to be. And I think that's reflected in your packet as well. Yep.
All right, who's here on behalf of 4239? Give your name and address, please.
Good morning. My name is Robert Elliott, 1611 Hark Reader Road, Mount Juliet.
Anything you would like to add to the comments?
Did I understand you're recommending to not approve?
Based on the language in the zoning ordinance, I don't have any right to recommend approval of this case, sir.
I bought, my son and I bought through a company 15 and a half acres that's reflected in the partial outline that you can see in the blue, subdivided that into 3 lots. The area in question is a residence that I built for myself. I am a builder. I did not, and it's my fault, I believed that the area in question was not a front yard. proceeded to build a beautiful new home that's, you can see in the, in the aerial view. The detached garage, the buffer, when you come down the 5-acre lot that is roughly 1,200 feet off the road, would back up to that 5-acre lot. The buffer is forested. There's a creek, stream that goes through there. There's an established flood elevation. And so the location, as a builder and as one who understands how to develop, where I'm proposing, and I didn't do this intentionally, but where I'm proposing that it would be built, nothing could ever be built close to it or even really seen because it's so far off the road. Because of the planning, it was part of a critical lot plan originally for my house. The base flood elevation in there is 602.2. I'll be building around 610. So, and that's been through, the flood review process with the county, and I think that piece is okay. But unfortunately, if I were to be required to do a 30-foot setback or even a 20-foot setback at this point, I would not be able to because of the road that I've cut in, the underground utilities that are already would be between the proposed build site, gas, water, septic, all of those things. So I've unfortunately put myself in a box, and I'm humbly asking for some grace on this. Anyway, that's my appeal.
Okay, thank you. Anyone here in the public that wishes to speak to case 4239? All right, hearing none, we'll close the public comment period and we'll go to the board. Anybody have any questions or concerns?
Looks like we call this the front yard, but it's 1,187 feet off the road.
Correct.
So I don't know how I consider it actually a front yard, but I really don't see anything. I mean, is anything detrimental about if we allow this variance?
I don't see any adverse effect, if that's what you're asking, no. I mean, anything that is parallel to a right-of-way per county standards is considered a front yard. And that's where that front yard setback's coming in this instance. But to answer your question, no, I don't see any adverse effect if the board chooses to grant this based off the distance and the rural characteristics of this area.
I will state that one of the reasons that we as a board, I guess legal reasons, can grant a variance is, of course, obviously grandfathered in, or I think, and staff, is that like an odd-shaped lot? Is that not one reason that we can legally grant variances?
Yeah, I mean, yeah.
Which this could be interpreted as kind of an odd-shaped lot because it's got a front yard that's 1,200 feet off the road, Just throwing that out there.
Yes, sir.
All right. Anybody, any more discussion or hear a motion or?
I'll make a motion to approve the variance of 20 feet.
Okay, we've got a motion to approve on case 4239. I will second that motion and amend it to, the reason for the approval is based on the shape of the lot. You accept that?
Yes.
All right. We have a motion to approve and a second. Everyone in favor, vote aye. 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 Opposed, no. Motion carries. Thank you. Okay, next on the agenda will be case 4240. Skinner Construction, on behalf of Che Ko, is requesting a variance of 5 feet from the southwest rear yard setback requirement of 40 feet. The existing deck is 35 feet from the southwest rear property line. The variance will allow the deck to be covered. The property is located at 2100 Donna K. Court, Lot 26, consisting of .79 acres and is zoned R1 residential. Staff recommendations on 4240.
Mr. Chair, the applicant is requesting a variance of 5 feet from the southwest rear yard setback requirement of 40 feet. Staff will note that the request will not exceed the building footprint of the existing deck for the home. The home is on record of being completed in 2004, so this is not an older tract of record with the lot being created in September of 2003. Therefore, given the language in the zoning ordinance, staff is unable to recommend approval.
Okay, who do we have here representing case 4240, Skinner Construction?
Jay Skinner, 4636 Lebanon Pike in Hermitage.
Yes, sir. Anything you would like to add, or?
Did you say the existing deck is the same size as what we're requesting, or did I miss
Yeah.
that?
No, that's what I stated. Is that not accurate?
The existing deck is slightly smaller than what we're asking for. That would, the existing deck, I believe, already encroaches on the setback, and we were looking to make a slightly bigger deck covered.
Okay.
So when we bring the roof on it, that's why I think we're here.
You're 5 feet over.
Well, the existing deck, I think, is 3 feet over, and we're trying to come 2 more feet
Gotcha.
and put a roof on it. So it would be a screen porch. But what was the reason for recommending denial?
It's a newer lot of record per county standards. Anything created after 1974 in Wilson County is considered a newer lot and has to abide by the rules that are in force currently.
Okay.
And the setback for that lot for a rear yard is 40 feet typically throughout the county.
Yeah. So the existing deck is already,
Encroaching, yes, sir. And that would, and I don't know if you lived there in 2004 when the home was built or not, but that's just something that went unchecked at that time.
So the existing deck itself is not in compliance today, correct?
Correct. It's my fault. I thought the existing deck was already 5 feet over. He's stating that it's 3, and the addition that he's wanting to put will be an additional 2.
Right, but the request is right at 5 feet.
That is correct, yes, sir.
I got you.
yeah, I mean, we would tear off the existing deck and build a new structure.
And with Christopher, as far as the deck being covered or uncovered, that does not.
That does not play in it, no.
That does
It
not
just,
play into it.
anything footprint-wise has to meet the
Okay.
setbacks.
Any questions from the board? How does the fact that it's a corner lot, does that play into this issue at all?
I looked
Or
at
is having
that.
2 rear yards and 2 front yards?
I looked at that, and I did not mention that because the direction that this house is facing, regardless if you wanted to try to utilize the corner lot provision, this rear yard would be the primary rear yard, even if you were trying to validate it as a corner lot. Now, if he was putting it on the other side of the house where the driveway is located, I could see how that would be considered maybe a corner lot hardship due to the fact that that would have a 40-foot setback as well. But the direction that his house is facing, this would be the primary rear yard regardless of whether or not this was a corner lot.
All right. I don't know if is there anyone else here that wishes to speak to this case? 4240. You want to speak? Okay. Name and address, please.
Che Co, 2100 Donna K Court. I'm the owner of the house. And just kind of brief history on it, but I think we're like the one of maybe 2 in the neighborhood that does not have a covered deck, and so we were trying to make it somewhat nice. The current deck is falling apart, and it's very dangerous to be on. And so in order to redo the deck, we decided that, we're going to go and cover it, and had some plans to make it somewhat nice inside with a wall, maybe a TV, and, create a space for the kids to kind of enjoy outside as well. So with all that being said, kind of humbly asking for some of the variants to be approved so that we can actually make those ends meet.
Right. Thank you. Any questions from the board?
I got one question. Did you live in the house in, what was it, 2004?
No, we moved
So you
in.
bought it, when you bought the house, it was existing the way it is today?
Correct.
Okay.
And the variance is not excessive. I mean, it's a 5-foot variance.
That's
So
correct, yeah.
It's not an excessive variance, but just for,
Very reasonable.
right. All right, do I hear a motion?
I'm going to make a motion that we approve this.
Okay, we have a motion to approve. Second. Have a motion to approve and a second. Everyone in favor, vote aye. Aye. Opposed, no. Motion carries. Thank you. Okay, next on the agenda will be case 4241. Robert Thomas Glees Living Trust is requesting a variance of 25 feet from the rear yard setback requirement of 40 feet. The variance will allow the proposed house to be 15 feet from the rear property line. Property is located at 451 Braid Drive, consisting of approximately 38,750 square feet and is zoned A1 agricultural. Staff recommendations on 4241.
Mr. Chair, the applicant is requesting a variance of 25 feet from the southwest rear yard setback requirement of 40 feet. This is an older tract of record with the lot being created in November of 1959. Staff will note that this property, this variance request does back up to the U.S. Corps of Engineers property. Therefore, given the language in the zoning ordinance, staff can recommend approval.
Okay, who do we have here representing 4241? Good morning.
Good morning.
Name and address, please.
Robert Leaves, 451 Braid Drive.
Anything you would like to add?
No, the current structure is 15 feet from the property line. Next door neighbor, Rudy Bostelman, they are 15 feet from the property line. Neighbor 2 doors down, Troy Dunnigan, just got an approval for 15 feet for an addition on his.
Obviously, these are, this neighborhood involves a lot of older lots of record, I'm assuming, and it seems to be a...
It's mixed. They've just built some new houses down through there.
Yeah, but I said older lots, not older houses, but older lots, yeah. But anyway. All right, is there anyone else here in the public that wishes to speak to this case? All right. Have any questions from the board?
No.
All right, hearing none, I close the public comment period. Turning to the board, we have a motion or?
Make a motion to approve based on staff recommendation.
Have a motion to approve, a second?
Second.
All right, a motion and a second. Everyone in favor, vote aye. Aye. Opposed, no. Motion carries. Okay. Going to case 4242. Burr and Foreman are requesting a renewal for a short-term rental. The board approved the short-term rental on August 18th, 2022 for a period of 1 year. Applicant is also needing a variance from the lot size requirement of 2 acres. The property is located at 135 Cherokee Dock Road, Lot 8, parcel 11 on Wilson County tax map, consisting of 1.25 acres and is zoned R2. Staff recommendations on 4242.
Mr. Chair, the applicant is requesting to renew an approval for a short-term rental. The short-term rental was granted for 1 year on August 18th of 2022 with the following conditions. Maximum number of occupants is 8. The business plan was part of the approval, and quiet hours are between 9 p.m. and 7 a.m. The business plan staff received upholds the conditions listed above. The use and amenities of the properties have not changed, nor have there been any public complaints about the property to staff's knowledge. Since the applicant's initial approval, the minimum lot size for short-term rentals was increased to 2 acres on December 16th of 2024, which this property does not currently meet. Because the short-term rental approval was allowed to expire in August of 2023, the applicant is no longer grandfathered in with their 1.2 acre lot. Given the language in the zoning ordinance, staff cannot recommend approval of this request.
Okay, who do we have here representing 4242?
Nathaniel Beaver, 2210 Harding Place, Nashville, Tennessee.
All right, anything,
In terms of the expiration, that's 100% on us. We operate Airbnbs in other counties, and they renew differently in terms of the notification of it, and that is completely on me, and I take credit for that expiring. The one thing I want to bring up with the 2 acres, this lot's 1.25 acres, but we actually have over 18 acres. We own 135, 155, and 175, and then we also own, oh my gosh, I'm forgetting the address. 10775 Highway 109. It's all connected. From a logistical standpoint, we could lease 3/4 of an acre of 17752 to this to make 2. But really, what's the purpose of it? We run the event space at Cherokee Dock, and we rent these out to, it's almost always the bride's family or the groom's family that's coming to have their wedding there. This is not a 200 a night Airbnb and so forth. It is part of our conjunction with it and so forth. It's not a highly trafficked area. So if the only issue is the 2 acres, I would request, I guess, for instance, that as opposed to going and releasing 3/4 of an acre to get over 2 acres, which we have connected to it if we needed. But it's an 18-acre property that just happens to be broken like this as we do.
okay. Anybody here in the public wishes to speak to case 4242? All right. Turning to the board and staff. Any questions and comments? And I think the big issue here, obviously, before the board is the 2-acre deal. So we need to hash that out and see what we're going to do with all that. And Mr. Jennings, anywhere you want to jump in on this, feel free to.
Okay.
And to the applicant, my first thing would be, it'd be easy on the board if you just make this a 2-acre lot, if that's doable.
I mean, I can write a lease agreement and lease my own property back. I mean, they're owned in separate lots, but that is absolutely not
That would have to be done via plat. We'd have to have a legal 2-acre tract with a subdivision plat.
And do that. I request that from the consideration of that, since we own 18 acres contiguous here, that was the purpose when we came 2 years ago. We haven't had one complaint or use of anything for it, and that it's part of an ongoing use and business behind it, that we could have an exception as opposed to the 2 acres, and that we have been granted before and we haven't violated anything.
And I hear the part about this is part of a bigger area, but yet we as a board have to consider the fact you may sell this. Somebody may sell these tracts individually, and then all of a sudden we've got a tract that's, instead of being 2 acres, it's 1.2, and it can't be made any bigger at that point in time because it's.
Can I ask a question?
Well, yeah, sure.
Could we have a stipulation that if the property's ever sold, that the permit never goes there? Because to be clear, it's not. I know it won't sell because I can't run the back without it, but if I were ever to sell it, I could completely understand that I couldn't market it as a short-term rental property. I'm selling it and it loses the permit.
You can make that a stipulation. I am going to caution you that staff does not track property sales in the county. So that would be up to, at that point, if he chose to sell it, obviously the use would lapse. But we're not doing due diligence to check property sales throughout the county.
The other aspect about this that is quite unique is this is a R2 zoning. I don't think we as a board are going to get many Airbnbs on R2 zoning.
These are the only 2 current, or were the only 2 currently in the county.
So we're definitely not going to get another Airbnb that's in existence that's less than 2 acres in R2. I mean, we may get them in A1, but we're not going to get them in R2 if these are the only ones, correct?
Correct, yeah, these would be the only ones.
So there are some exceptions to this that may not apply.
And R2 lots going forward, I mean, with the 2-acre minimum now passing that, those may be few and far between, because the minimum lot size for R2 is 20,000 square feet, and that's what developers will typically exercise. These are obviously larger lots, because I believe this was part of the McIntyre Estates when it got liquidated. But, so I mean, Airbnbs as a use in R2 may seem to kind of fizzle out.
Right.
So this is one of 2 that are in R2 right now in existence?
The other one.
They're the only 2, yes, and the other one is the one,
Tied together in the same area here.
Right.
yes, sir.
So we always have to be concerned for the applicant about precedent. You know, if we do this, we do 20 more people come
Exactly.
in over the next year and say, I want the same deal. But if it's only 2, and this gentleman owns them both, precedent probably is not going to be an issue there. So that may be something you want to think about.
I also want to bring up to the other house that we mentioned that is the 4th property that's connected to this. There is a full-time caretaker of all 4 properties that lives there and oversees it. And I completely fall on the sword. It was my fault not to come back at that year. And had I, this obviously wouldn't have been an issue. But it was more of an oversight there with it. And I request to, be able to keep running it as it is with it.
Let me ask you a question of Christopher, too.
Yeah.
You don't feel comfortable with this, whatever, but if he had been back on time
Yeah.
and the law had changed for a 2-acre requirement, we wouldn't deny him at that point.
No, we would actually, as long as he keeps up with his approvals, we would have recommended approval of that going forward, just because it was in effect and that it never lapsed.
And on,
We'd be on thin ice if we tried to deny on that basis. So you got some things you can work
well, and on that same note, I guess, had this new 2-acre just has gone into effect. Had he been here a month ago or 2 months ago, your recommendation would be for approval.
Well, I mean, even if he were here last month, I mean, it went into effect December 16th, but everything you heard last month was December 20th, but all the applications had already been made. So if he would have been here,
There's a time period that he's not in, I mean, he hasn't been in compliance, but a part of your request is based on the fact that he's a month too late. If he'd have been here at our last meeting.
well, yeah, I mean, I would argue with that. He's a month too late, but
But
for
he
staff's
wasn't, well, I
opinion, he's
understand, right.
18 months too late.
Well, I understand
Yeah.
that, but as far as the 2-acre deal, yeah, I understand.
Yes.
Okay.
Sounds like one of these things, sometimes it's better to be lucky than good.
I'm not feeling real lucky today, but anyway, I hope everybody else is.
Neither am I.
All right, well, back to the board. Any comments,
I
motions?
want to make sure we have limited exposure to this 1.2 acres, because I don't want people start flooding the courthouse saying, well, you gave that guy 1.2 acres and I want it, because I'm not getting that, because regulations are there for a reason.
And understand,
Change to 2 acres for a reason.
Right.
Not trying to be hard, but we have to limit our exposure, or I want to limit my exposure to how we treat everybody fairly.
Yeah, absolutely. And to be clear, as a business owner, I appreciate that. I don't want
As long as it's
everyone
limited,
getting one.
and we're not opening up a can of worms, I'm good with it. But I know, Justin, you brought up one thing about the bedrooms and the number of people.
We're a 4-bedroom perk site, and both business plans are listing 10 guests. Can you revise that business plan down to 8 guests?
Yeah, that's absolutely fine.
There's 2 per bedroom.
Yeah,
I got it.
absolutely.
Not really a question, I guess.
They don't have to be a question.
I'm kind of looking at this, even though he's late requesting. I'm almost looking at this as grandfather rights, because he had them before the rule changed. And the county commission, we got one here. I mean, they're the ones that passed it, and they didn't put any language in there about grandfather rights or anything else. So it's thrown back on us. So that's the way I would look at it. Even though he's late, I would look at it almost that he's got some grandfather rights here.
Right. I could agree with, he was in compliance. I mean, you know, this is totally different than somebody brand new walking in here and not having 2 acres, you know. He was in compliance at one point in time, and then he, you know, and then the rules have changed while he was, you know, he did lapse in his renewal, which he's admitted to, but yeah.
My recommendation would be is that we do go back and approve for 12 months.
Yes, sir.
Not more. And normally if you came back within time, we would give you a couple of years and then maybe the next time 5. So my recommendation.
Do you want
I'll make that motion.
Yeah. Go ahead and if you want to rephrase all that again, yeah, in the form of, well.
I'll make a motion, we approve for 1 year. Based on, I'm just going to say based on the grandfather rights is the way I look at it.
Okay. I'll second that motion, and I want to slightly amend and bring in the fact that this is a R2 zoning, based on the fact, and also bring in the fact that based on testimony given today, he has all the surrounding property, and there's more to this than just this one lot. And maybe that's making it cloudy, but I'm trying to make this case here be something that everybody else can't piggyback off of it going forward. But he's got surrounding property that goes with this, and this is part of a larger use that they manage. And I don't know if that wasn't very clean, but absolutely.
I have an issue with this. And the reason I have an issue with this is because, first of all, that's your responsibility to make sure that you come back in front of this board for renewal, and you are way late on both of these. So I have a problem with that. And in the meantime, we have a 2-year stipulation here. 2 acre, 2 acre stipulation here. This, to me, sets precedent. And been doing this a long time, I have an issue because this isn't going to be the last one that we hear about this. You're going to have others that have gone a year or whatever without coming back in front of this board, and we're setting a precedence here. I understand where you're coming from, but this is 0.6, this is not even an acre.
Yeah, he's 1.2 of an acre.
The other one's not, though.
Oh, yeah, right. There's, right.
The other one's not. You're not in compliance. You're not into us where we have, put this out there and approved that to be 2 acres.
And if,
So I just don't want this to come back to this board.
Well, it's coming back.
It's going to come back.
It's coming back.
So
Yeah,
we're
it's
setting
coming
the
back.
precedence here, to me, in my opinion, only, that we're setting a precedence here that's already.
And that was a part of my amendment as far as a part of this is based on the R2 zoning. But we're going to get more of these coming back under the A1 zoning. So how we deal with them going forward, remains to be seen.
I think this is a unique situation because he does run an actual business there besides the Airbnbs, and the Airbnbs contribute to
Right.
his
I think there's circumstances to this particular case that may not apply to everyone else.
But you're going to have to explain that every time somebody comes up.
That may be true. That may be true.
That'd be up to Rusty, wouldn't it?
No, Rush is going to look back at us and say, y'all the ones that created this. Y'all get your own self out of this. But anyway. All right. Any more discussion? Or
I think we need to make sure it's included no more than 8 guests.
Okay, yeah. Absolutely.
Even though he recognizes that, but it still says 10.
Okay. All right, we have a motion to approve this, and we've amended that motion based on the fact that it is our R2 zoning and the fact that this is part of a larger area that you manage property-wise. We also want to make sure that it's limited to just 8 guests, and it was for 1 year. Christopher, is that kind of got everything in order on our motion and our second?
Yeah, and then the only other thing would be to make the amended business plan part of the motion.
Okay, the amended business plan will be a part of the motion. Okay. All right, does everybody understand what the motion and second is? Okay, then if everybody's ready, we'll vote on the motion. Everybody in favor, vote aye. Aye. Opposed, vote no. No. Have one no and 4 ayes. Okay. All right, motion carries. All right. Don't go far. Don't go far. All right, case 4243. Burr and Foreman are requesting a renewal for a short-term rental. The board approved the short-term rental on August 18, 2022 for a period of 1 year. Applicant is also needing a variance from the lot size requirement of 2 acres. Property is located at 155 Cherokee Dock Road, Lot 9. Parcel 12, Wilson County, Texas, consisting of 1.33 acres and zoned R2 residential. All right, staff recommendations.
All right, Mr. Chair, these are going to be very similar. The applicant is requesting a renew and approval for a short-term rental. The short-term rental was granted for 1 year on August 18th of 2022 with the following conditions. This one had the maximum number of occupants is 10. The business plan is part of the approval, and quiet hours are between 9 p.m. and 7 a.m. The business plan staff received upholds the conditions listed above. The use of the amenities of the property have not changed, nor have there been any public complaints about the property to staff's knowledge. Since the applicant's initial approval, the minimum lot size for short-term rentals was increased to 2 acres on December 16th of 2024, which this property does not meet. Because the short-term rental approval was allowed to expire in August of 2023, the applicant is no longer grandfathered in with their 1.3 acre lot. Given the language in the zoning ordinance, staff cannot recommend approval.
Okay, the applicant will come forward and give your name and address again.
Daniel Beaver, 2210 Harding Place, Nashville, Tennessee.
Thank you, sir. Of course, obviously, we're pretty similar to the last one, I guess. I will say, I think the business plan calls for 10, and I think you've only got platted for 4.
I do need to make a correction. My comments said that the original approval was for 10. The septic record on this property is a 4-bedroom perk, which would allow 8.
8, okay. So the business plan would need to be amended to 8 applicants. All right. To the public, anybody here in the public have any comments on this case? All right, turning to the board, any discussion, questions, or motions, or? For the most part, it's exactly the same as the last one. For R2 zoning, both of these lots are quite a bit larger than what they would have to be. You know, they could be down to a half acre, and these are both.
Yeah, I mean, they're 3 times the size of the minimum.
Sir?
They're 3 times the size of the minimum.
Right in R2 zoning, yes, yeah. But, all right, do I hear a motion? All right, I guess I'll wade into this one. I will move that we approve case 4243 with the amended business plan, which calls for a maximum of 8 applicants or 8 people staying. I will move that we approve it based on the fact that it is a R2 zoning. It is a part of several other properties. The owner has several other properties that are adjoining, and it is a part of those others as far as in the business operation. I will approve it for 1 year. And then I guess, has that covered everything, Christopher?
Yes, sir.
All right. I have a motion to approve. Do I have a second?
Second.
I have a second.
Who seconded it? Manning.
All right. Everybody in favor of the motion as stated, vote aye. Aye. Opposed, no?
No.
No, okay. Have 4 to 1, motion carries.
Thank you.
Let me just remember to come back.
Yeah.
Absolutely.
Yeah, don't make us go through this again.
Don't wait till the last month. Come back a couple of months. It's going to be her fault.
It's going to be the attorney's fault. Yeah, it will not be an issue.
Okay.
Different renewals in this county versus.
Because things may change.
Yeah, we may renew tomorrow. So.
Thank you. All right. Thank you. All right. Moving on to case 4244. Kevin Sparks with Signature Pools on behalf of Paul Fedorenko, and applicant is requesting a variance of 3 feet from the setback requirement of 8 feet between structures. This is not an older lot of record. I may be reading staff's recommendations, am I?
You are. You can keep going if you like.
I got ahead of myself on that one. That always happens. All right, let me read the applicant's request. 4244. All right, here we go. Kevin Sparks with Signature Pools on behalf of Paul Fedorenko is requesting a variance of 3 feet from the setback requirement of 8 feet between structures. The variance will allow the proposed pool to be 5 feet from the existing deck. Property consists of 35,480 square feet and is zoned R1 residential. Now staff recommendations.
Mr. Chair, the applicant is requesting a variance of 3 feet from the setback requirement of 8 feet between structures. This is not an old or attractive record, with the lot being created in August of 2021. Therefore, given the language in the zoning ordinance, staff cannot recommend approval. On the site review, this lot has a significant slope to where a retaining wall has been constructed, which is a significant one, to create a flatter backyard. Due to the slope of this lot, the board may choose to interpret this as a hardship for the lot if you choose to approve this request.
Okay, who do we have here representing case 4244?
Hi, I'm Leanne Kimberlin, 2349 Church Street, Murfreesboro.
Thank you.
I just wanted to add a few issues that we have discovered per the contractor. I was going to mention that it is a critical lot with the slope in the back. Therefore, they did hire an engineer to do the original house plans and yard plans. There's a small picture on your photo of the design. I think, do y'all have that picture? Sorry. That shows the height of the wall. The wall is probably about 10 to 12 feet in some issues. Did y'all not get that one? Oh, there it is. Yeah. Okay. So when he did this, the yard was made to be a small yard. It was all built up to be as level as possible. The homeowners who are contracting to build this place and contracted us to build a pool, they wanted the small pool spa combo, and the width of that is just 12 feet. And that's the minimum you can have when you build an in-ground pool with a spa inside of it. The reason it's, I believe, 4 feet from the wall is because we have to be allowed to have a dig and to put the pipes in. The reason we're asking for the variance is because there's no more room. There's only 5 feet from the house to the water line, and that would allow us enough room to put pipes. The other thing I would ask you to consider is we were told by the contractor of the house that this place is up for annexation and that it appears that annexation will happen, and if so, I called the city of Mount Juliet, and they informed me that they do not have the code of 8 feet from the structure of the house. They do not have a code at all. They said the water line can be right on the house. So I just thought if you could take that in consideration, that it's probably going to be moving to the city and that they don't have that code. So if you have any questions.
All right, thank you. Anybody have any questions for the applicant?
I don't have any, maybe just corrections. I don't know where you're getting your information. This particular development is so far north, I don't even believe it's in an urban growth boundary to be considered for annexation.
Really, that's what they do.
And all these lots are traditional septic, which the cities, in most cases, won't annex an entire development that has septic approvals. This had very good dirt for Wilson County standards when it was developed in 2020. But I don't even believe this property, I'll have to double check, but I don't believe this property is within a distance where it's even under the ability to request annexation. I mean, that's not pertinent to your all's decision or anything, but that's just a point of information.
Right. All right. Anybody here in the public have any comments on this case? All right. Turning back to the board.
I'll make a motion to approve.
All right, we have a motion to approve. Second?
Second.
Second. All right, everyone in favor, vote aye. Aye. Opposed? All right, motion carries. Thank you. Okay, this might be the case we've been looking for.
Who was the second on that, sir? Man, okay.
Dustin. Okay, case 4245. Got to get my right paperwork here. Give me just a second now. All right, here we go. The request, Neil Rancher on behalf of Chase Ginther is requesting a variance of 19 feet from the rear yard setback requirement of 40 feet for the existing house. The existing house is 21 feet from the rear property line. The variance will allow the property owner to build an addition that will meet the rear yard setback requirement. Applicant is also requesting approval for 2 existing houses on 1 tract of land. Property is located at 5095 Central Pike, parcel 69.02, consisting of 1.8 acres and is zoned R1 residential. Staff recommendations on 4245.
All right, Mr. Chair. Bear with me on this one a little bit. Applicant is requesting a variance of 19 feet from the rear yard setback requirement of 40 feet for an existing house, as well as requesting approval for 2 existing homes on 1 tract of land. There's not a recorded plat for this property, but based on tax records, the 2 homes on the property appear to have been built in 1963 and 1973, both of which predate zoning. Staff would note that this property does not have enough square feet to be subdivided into 2 legal tracts. The tract in question appears to be an older lot based on the completion date of the homes. To staff's research, there was never a recorded plat created to subdivide this lot from the main farm. There is, however, some deed documentation, the most recent dated in 2017, that references the address tract, so it is at least acknowledged in somebody's title work. There's also further documentation that the tract was included for reference in a plat that was done in 2003. That plat, however, was never recorded until 2014. So, I mean, I'm able to get the property back to 2003. After that, it gets really fuzzy on how it came to be. Staff can recommend approval of the request due to staff's interpretation that this is an older tract of record. Staff will mention that an up-to-date plat could help to resolve some questions that may be presented in the future.
Okay, we'll get who's here to represent case 4245. Yes, sir.
Neil Ranta, 105 Fair Lake Court in Hendersonville.
Okay. What can you tell us about all this? Got a lot going on there.
Yeah, I just signed up to build a little addition in the back, and then found out that there's a whole lot going on. Yeah, we're just trying to bump out the back a little bit to extend their bedroom and give them kind of an ensuite with a walk-in closet. So the rest of it just happened. Not really touching anything else. Whatever addition they did in the back with that carport, I think was done originally or shortly thereafter, and that's the issue with the setback. So it's not really, it's just a covered patio basically, but it's still.
And the bigger question may be the 2 houses on 1 lot.
Yeah.
Who, I mean, I'm assuming, are they family members on both houses, or who?
I have no idea.
You have no idea?
So the owners live in the 1 unit, so I don't know if it's family that's there. The times that I've been there, I haven't really seen a whole lot of activity. I just think the house is just there.
Okay. Anybody, the board, have some questions or comments? Staff, does it?
I mean, as far as the setback, I mean, his addition is not going to encroach any farther than the existing home, which was built in, I believe this is the newer of the 2 homes, and this one was built in '73, which still predates our zoning ordinance. So staff does not have an issue with the setback, more or less. The fuzzy part is the 2 homes, which
Absolutely.
If the lot was legally created prior to 1974, that would just be more of a clerical issue for you all, as we have 2 homes on some older farm lots in the county.
Right, so even the 2 homes could be grandfathered in if.
Absolutely. In this case, based on their construction date, I wouldn't have any reservations with that. The way the lot has come about in the interim since the larger house was built in '73, I just don't know how that was created, because the title work that's referenced on this property, I'm pretty sure, is mislabeled, and it doesn't actually mention the property to any detail. The deeds that do mention it are for deeds of other tracts. The most accurate one is actually the one on the other side of Central Pike that references it as an address. But as far as how it came to be with the acreage it has, I've not been able to dictate all that, but I'm going to let you know I am not a title searcher. I'm doing this to the best of staff's ability.
Right. Do we have anybody else that wishes to speak to this case? No? All right. Turning to the board. Does it, I guess it doesn't matter, I mean, obviously the lot is owned by one person, so both houses are owned by the same people, correct?
Yes, sir.
That would have to be, and then,
Unless there's some sort of rental or informal ownership agreement that I'm not aware of.
well, and I was going to say, so it really, as far as this board's concerned, does it matter whether they rent the second house out or family? That
No, sir,
doesn't matter,
no.
does it?
No, absolutely not. You're just proving it whether or not you're going to allow this to continue as a non-conforming lot with 2 residences on it.
Okay, all right. Turning back to the board.
I'm going to make a motion that
Okay.
we approve this, per staff recommendation, but also because it's showing that this is an older track of record.
Okay.
When the house is.
Absolutely, absolutely. Have a motion to approve based on staff and the fact that it's an older lot of record. Do I need a second?
I'll second.
I have a motion and a second. Everyone in favor, vote aye. Aye. Opposed, no. Motion carries. Was that our last one? I keep thinking we're at the end. What we got here?
Yeah, they would have to come back before you in that instance.
All right, I believe we're about to get to the crowd getting thinner out here. Yeah, we're down to hopefully the last case, maybe. I don't know. Case 4246, request is Jeffrey Brandon is requesting a variance of 9 feet from the north side yard setback requirement of 15 feet. The variance will allow the proposed addition to be 6 feet from the north side property line. The applicant is also needing a variance of approximately 19,650 square feet from the lot size requirement of 40,000. Property is located at 508 Clearwater Court, Wilson County Tax Map 31J, consisting of approximately 20,350 square feet and is zoned R1 residential. Staff recommendations on 4246.
Mr. Chair, the applicant is requesting a variance of 9 feet from the north side yard setback requirement of 15 feet. This lot also needs a lot size variance of 19,650 square feet from the required 40,000 square feet. This is an older tract of record, with the lot being created in April of 1966. Therefore, given the language on older tracts of record, staff can recommend approval.
Okay, who do we have here representing 4246? You want to make any statements or anything, or name and address?
Name and address, Jeff Brandon. 508 Clearwater Court.
Okay. Anybody on the board have any questions? Anybody in the public have any comments? All right, turning to the board.
Make a motion to approve based on staff recommendation.
Second.
I have a motion to approve on staff recommendation, a second. Everyone in favor, vote aye. Aye. Opposed, no. Motion carries.
Thank you all very much. Appreciate it.
Thank you for your patience. Is that it? Anything?
I don't have any additional points of interest, no.
Okay. I have a quick question maybe for you, I guess, Christopher, before we close. Do we as a board need to do or worry about our continuing education? It seems like we have not done, seems like we have not done that in quite a while.
Throw that right back on me. Yes, that is. That is something you do need to consider, and something that I will have to work on setting up. It'll probably be a joint meeting between you all and Planning Commission in this instance, since this is my first go around to try and catch everybody back up, but
Right.
yes.
And I wasn't trying to throw you under the bus. I just know that seemed like we've lapsed quite a bit on that. And
I hope it's not quite a bit, but yeah.
okay, well, right. And I didn't know what it had to be to qualify. I didn't know could we sit in on any other public meetings and count that as continuing education? Or
No, no.
Oh,
It has to
okay.
be some sort of certified educational experience, which we've typically done in the past, which, I mean, they're all over the state. There's the opportunities, and I can send you a list if you want to go elsewhere. We've typically in the past done, you're required 4 hours per year, I believe is the state requirement. Is that right?
I think it was 8.
8?
I hope you're right.
Okay. Well, whatever it is, we've typically done, maybe it's 8 hours every 2 years. Does that sound better?
All right.
Is it 8 hours every 2?
Board, how many of us have been through continuing education?
Regardless of what the requirement is, I'll nail down.
Everybody's been through at least, okay, that's good then.
Regardless of what the requirement is, I'll nail down that number, but in the past, we've typically done a 4-hour continuing education session.
Not a big deal, I just,
at once.
Okay.
So when we've done it, it's typically from 5 PM to
right on.
9 PM, which is long, but it knocks it out all in one session.
I got you, I understand. All right.
Grandfather yourself,
I feel like I've been through a few of them, but I didn't know what the requirements were. I was thinking maybe we could sit in on some kind of meeting and get it and count that, but anyway. All right, well, I'm done, I guess. We're done. Meeting adjourned, yes.